Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. The outline of the Japanese Maritime Law. Sources of Maritime Law. The third book of the Japanese Commercial Code is titled as Maritime Commerce. It is, of course, the principal source of maritime law in Japan. However, it is not the only source. The reason is twofold. First, after the codification of the Japanese Commercial Code in 1899, tremendous efforts have been made by lawyers in the work toward the unification of maritime laws of various jurisdictions. These efforts have been so successful that many uniform law instruments have been produced. This means that the original Japanese code has become outdated in some respect when Japan has acceded to some of these uniform laws. It was preferred to enact an independent statute to implement them rather than modify the code greatly. Thus, the International Carriage of Goods by Sea Act would implement the Brussels Convention on Bills of Lading, HUVSP, rules as amended by SDR Protocol and the Act on Limitation of Liability of Ship Owners and Others, hereinafter ALLS, implementing the 1976 Convention on Limitation of Liability for Maritime Claims, form integral part of maritime law in Japan. Secondly, the maritime law, though unique enough, is based on the general principles of civil and commercial law. The carrier's liability is nothing but the liability arising from contract or tort which is governed by the civil code. Maritime liens and mortgages on ship are special kinds of secured interests which again are regulated by the civil code. And a bill of lading, as a kind of instrument that is negotiable, requires comparative analysis with other instruments like a bill of exchange or a bill issued by a warehouse operator. Thus, due regard would be needed to be paid to the coordination between maritime law and other rules of civil or commercial law. It might be added that the Book 3 of the Commercial Code itself refers to numerous provisions of other parts of the same code. The law of transport in general, principally governing the transport on land, as codified in Book 2, Chapter 8 of the Commercial Code, c. Art 766 and Art 776 of the Commercial Code. And then the next is carriage of goods. An agreement of carriage of goods is a contrast between a carrier who undertakes the carriage and his customer. Japanese law, as many others in the world, knows two types of such contract. One is the carriage of general cargo, which means the carriage of one or some specified cargoes. The other is a charter party, in which the carrier reserves the whole or partial space of the ship at the disposal of the other party, charterer, and undertakes to carry whatever cargo loaded onto the chartered space. Number 1. Carriage of general cargo. Duty of the carrier under the contract of Number 1. Carriage of general cargo. Duty of the carrier. Under the contract of carriage of general cargo, the carrier owes obligation to exercise due diligence about the seaworthiness of the ship and about the goods. Pursuant to the Brussels Convention, the ICHOCSA provides as Record the duty of the carriers about the seaworthiness that the carrier shall be liable for loss, damage, or delay of the goods resulting from failure of exercising due diligence to make the ship seaworthy, to properly man, equip, and supply the ship as well as to make the holds. Refrigerating and cool chambers and all other part of the ship in which goods are carried fit and safe for their reception, carriage, and representation. It is understood that the seaworthiness is required at the beginning at the navigation only and not throughout the journey. Secondly, it is provided that the carrier should be liable for the loss, damage, or delay of the goods resulting from not exercising due diligence suppose receiving, loading, stowing, carrying, keeping, discharging, and delivering of the goods. Under IJOXA, the liability of the carrier with regard to these duties is based on the presumed fault system. It means that the carrier shall be liable unless he is successful in providing that neither he nor his servants and agent failed to exercise due diligence as required. This is consistent with the general rule of contract since in Japan, a debtor cannot rebut his contractual liability unless he proves that there has been no fault in his side upon non-performance of the obligation. On the other hand, the principle of presumed fault system is not totally in concordance with the underlying idea of the Brussels Convention. The Brussels Convention derived from the rules of common law, which were historically based on the absolute liability, and the exemption clauses in the bills of lading to escape from it. It is because of this background that the IJOXA is drafted in a slightly different way from the Brussels Convention and treated the list of accepted perils as the list of events to shift the burden of proof about the existence of the carrier's fault, rather than the list of exemption from liability only a fault in navigation or in management of the ship, as well as fire are provided as exemption in the strict sense, since these two events normally constitute fault of the carrier and therefore render the carrier liable if there had not been a statutory provision of exemption. There is also a special rule on the carriage of valuable goods unless the shipper declares the kind and the value of the goods of the time of consignment. The carrier shall be exempt from any liability. This is because valuable goods require greater care in handling, which may in turn require special rate of charge. Declaration of the kind and value of the goods gives the carrier an opportunity to be prepared for careful handling as well as to claim the special charge. And then liability of the carrier. The carrier, if found being in breach of his duties, shall be liable for the loss of or damage to or delay in delivery of the goods. In other words, the carrier has to compensate for the harm that the party interested in the goods has incurred from such accident. The accident must have resulted from failure of due diligence of the carrier. According to the general principle of contract, the harm that needs to be compensated includes such harm as will accompany with the accident at issue in the ordinary course of things, and such harm resulting from the accident due to special circumstances as long as contemplated by both parties. The amount of compensation must be such that puts the harmed party to the equivalent situation that he should have been in but for the accident. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe to the channel. See you in the next video, and bye bye.